Here's a real-life scenario of what could happen when a seller learns about FIRPTA 1 week before closing. Scenario: FIRPTA surprise. Just before closing background, Maria, a citizen of Canada, owns a vacation home in Scottsdale, Arizona. She lists the property for sale and accepts an offer from a U.S. buyer. The deal is moving smoothly, and they're scheduled to close in 1 week. The twist. During a final document review, the escrow officer asks Maria for her U.S. taxpayer identification number, TIN, to complete the FIRPTA forms. Maria is confused. This is the first time she's hearing about FIRPTA. She doesn't have a TIN and had no idea that, as a foreign seller, she might be subject to a 15% withholding on the gross sale price. What happens next? 1. Closing is delayed. Because Maria doesn't have a TIN, the buyer cannot file Form 8288A, and the IRS won't accept the withholding without it. The escrow company cannot disperse funds until this is resolved. 2. Maria applies for a TIN. She has to submit Form W-7, Application for an IRS Individual Taxpayer Identification Number, which typically takes several weeks to process. This delays the closing unless the buyer agrees to an extended timeline. 3. Maria considers Form 82888B. Maria's tax advisor recommends she file Form 8288B to request a withholding certificate for a reduced or zero withholding, but this also requires a TIN, and IRS approval usually takes 90 days or more. 4. Buyer's dilemma. The buyer learns that they are legally responsible for withholding and submitting the 15% FIRPTA tax. If they don't do it correctly, they could be on the hook for the entire amount, plus penalties and interest. 5. Resolution. Eventually. The deal is amended to extend the closing by 45 days to give Maria time to obtain her TIN. Once received, the buyer submits Form 8288 and 8288A to the IRS with the withheld amount. Maria can later file a U.S. tax return to request a refund if her actual tax liability is lower. Moral of the story: FIRPTA surprises can cause major closing delays and financial headaches. Foreign sellers should be informed early in the transaction to avoid last-minute chaos. Sellers may cancel due to funds not available to have for the withholding of the 15%. Sellers may sue the broker and agent for not disclosing or informing them of the requirements. Buyers could also sue for losing the property if the seller cancels. FIRPTA gets a little tricky when it comes to mixed citizenship couples, where one spouse is a U.S. person and the other is a foreign person under IRS definitions. Here's how it's generally handled and how to approach it in a real estate transaction. FIRPTA and mixed citizenship couples scenario. A married couple is selling U.S. real estate. One spouse is a U.S. citizen or resident alien, and the other is a non-resident foreign person. FIRPTA. Withholding rules. If both spouses are on title, the IRS treats each owner separately for FIRPTA purposes, so FIRPTA applies proportionally to the foreign spouse's share. Example: O. The couple sells their home for $800,000. O title is held 50-50. O. One spouse is foreign. FIRPTA applies to $400,000. O. 15% of $400,000 or $60,000 withheld and sent to IRS. If only the foreign spouse is on title, FIRPTA applies to the entire gross sale price. If only the U.S. citizen spouse is on title, no FIRPTA withholding is required. How to approach it. 1. Identify ownership shares on title early. Title determines how FIRPTA is applied. Even if a foreign spouse isn't involved in the sale paperwork, if they're on title, withholding may be required. 2. Check for a certification of non-foreign status. The U.S. spouse can provide this certification to avoid withholding on their share, but the foreign spouse cannot. 3. TINs are still required. If withholding is needed, the foreign spouse must have, or apply for, a TIN. Otherwise, closing may be delayed. 4. Consider a withholding certificate. Form 8288B. If actual tax liability is lower than the 15% withholding, the couple can apply for a reduced withholding. But plan ahead, as approval can take months. Pro tips: always disclose foreign status early to escrow, agents, and title so FIRPTA can be planned for. Escrow is not responsible for FIRPTA compliance, buyers are, but escrow usually facilitates the process. If it's a primary residence and sale price is under $300,000, there may be exemptions available, but only under certain conditions. Here's a case study illustrating a situation where a foreign seller owed more than the net proceeds due to FIRPTA withholding. Case study: seller owes more than net proceeds. After FIRPTA withholding background. Seller: Mr. Zhang, a foreign national residing in China. Property: Scottsdale, Arizona home, owned as a vacation rental. Original purchase price: $700,000, sale price: $650,000, mortgage payoff: $610,000, closing costs, income and commissions, escrow, $30,000 timeline. Mr. Zhang was unaware of FIRPTA and did not disclose foreign status until 5 days before closing. Key FIRPTA facts. FIRPTA requires 15% withholding of the gross sales price, not net proceeds. Buyer is legally responsible for withholding and submitting to the IRS. Aims awiwi, yet what happened? Buyer's agent, discovering Mr. Zhang's foreign status, alerts escrow 5 days before close. Escrow informs buyer $9,750 FIRPTA withholding, 15% of $650,000, is required at closing. Net proceeds to seller after paying off mortgage and closing costs: $650,000, $610,000, $30,000, $10,000. But FIRPTA requires $97,500, way more than the $10,000 available. Result aims high. FIRPTA. Withholding amount exceeded the seller's proceeds. Mr. Zhang had to bring $87,500 cash to closing to satisfy FIRPTA withholding. Escrow couldn't fund the sale until the full withholding was secured. Buyer's agent insisted on compliance to avoid IRS liability. How it was handled. Mr. Zhang applied for a withholding certificate, Form 8288B, to request a reduced amount based on no actual gain. But it was too late to get IRS approval before closing, so full withholding was still required. After closing, he submitted his U.S. tax return and claimed a refund for the over-withheld amount, received 9 months later. Takeaways. FIRPTA is based on gross sales price, not equity or profit. If sellers wait too long to disclose foreign status, they risk owe unexpected cash requirements, owe delayed closings, owe major tax refund delays. Sellers should apply early for a withholding certificate if expecting minimal or no gain. Here's a clear guide on when it's appropriate and smart to refer buyers and sellers to tax legal professionals for FIRPTA-related questions. When to refer to a tax or legal professional for FIRPTA. 1. When the seller is foreign and unsure of U.S. tax obligations, if they don't know what FIRPTA is, if they've never filed a U.S. tax return, if they're unclear about treaty benefits or tax implications, refer to U.S. tax advisor or international tax attorney. 2. When the seller wants to file Form 8288B, withholding certificate, to reduce or eliminate FIRPTA withholding, to calculate actual gain and avoid over-withholding. This requires detailed tax calculations and an ITIN, if they don't have one. Refer to CPA or enrolled agent experienced in FIRPTA. 3. If there's a mixed citizenship couple or complex ownership. One spouse is foreign, one is a U.S. citizen. Property is held in an LLC, trust, or entity. There are questions about who's considered the seller under FIRPTA. Refer to tax attorney or CPA specializing in real estate structures. 4. If they learn about FIRPTA close to closing, may need to assess how to comply quickly, might need help requesting a refund later, refer to tax professional for post-closing refund strategy. 5. If the buyer is concerned about being held liable, buyer is legally responsible for withholding and reporting. If unsure how to fill out forms 82888, 8288A, or when to withhold, refer to real estate attorney or tax advisor. Pro tip for agents in escrow: always disclose FIRPTA early and include a referral disclaimer like, "I'm not a tax advisor, so I highly recommend speaking with a qualified CPA or tax attorney about your FIRPTA responsibilities." This protects you and ensures your client gets accurate advice. February 2016 update. Pursuant to the Protecting Americans from Tax Hikes Act of 2015, the withholding for FIRPTA increased from 10% up to 15% under certain circumstances. Issue: a Canadian non-resident alien, i.e., has not acquired a green card, owns a home in Arizona free and clear. The Canadian non-resident alien has signed a contract to sell the home for $700,000. Will there be any tax withholding of the $700,000 proceeds of sale at closing? Answer: yes. Under the Foreign Investment in Real Property Tax Act, FIRPTA, 10% of the $700,000 sales proceeds, namely $70,000, must generally be held at closing by the escrow company and paid to the Internal Revenue Service. When the Canadian non-resident alien files a tax return for the year of the sale, the Canadian non-resident alien may be entitled to a refund of some or all of the $70,000. Note: there is no requirement for 10% tax withholding if the sale price of the home is $300,000 or less, and the buyer will occupy the home. Arizona Realtor Magazine, April 2011, updated February 2016. Be aware of FIRPTA tax withholding at close of escrow for foreign sellers. The Foreign Investment in Real Property Tax Act, FIRPTA, requires that if the seller of real property is a non-resident alien or foreign entity, foreign person, the buyer must withhold a tax equal to 10% of the gross purchase price at close of escrow, unless an exemption applies. A resident alien is not considered a foreign person and therefore not subject to the mandatory withholding under FIRPTA. If the seller is a foreign person, the necessary withholding can be accomplished by the escrow agent, who will require the seller's taxpayer identification number, collect the 10% of the purchase price, and forward the funds to the IRS at close of escrow. There are exemptions to the FIRPTA withholding requirement. For example, generally, if the purchase price does not exceed $300,000 and the buyer will use the property as the buyer's residence, no FIRPTA holding will be required. Additionally, under certain circumstances, a seller may obtain a qualifying statement from the IRS stating that no withholding is required. Of course, the most common exemption is when the seller furnishes a non-foreign affidavit stating under penalty of perjury that the seller is not a foreign person. However, be aware that the real estate brokers for either party can be held liable for the tax that should have been withheld, up to the amount of compensation received, if the broker has actual knowledge that the non-foreign affidavit is false and fails to notify the buyer and the IRS. The AAR residential and vacant land sellers' property disclosure statements ask if the seller is a foreign person pursuant to FIRPTA, and if so, advises the seller to consult a tax advisor since mandatory withholding may apply. The AAR purchase contracts also address FIRPTA withholding and require the seller to comply with the IRS reporting requirement and complete the non-foreign affidavit during escrow. Further, the buyer acknowledges in the AAR contracts that if the seller is a foreign person, the buyer must withhold a tax equal to 10% of the purchase price, unless an exemption applies. Foreign sellers should be advised to consult their tax professional regarding FIRPTA withholding. The seller can request the IRS to determine the seller's maximum tax liability with respect to the sale. FIRPTE information will be added to the buyer advisory at the next revision. Here's a little more on the Gilbert v. NMACA suit. The case of Eric and Audra Gilbert versus NMACA Management Limited highlights the complexities that can arise when purchasing property from a foreign entity, particularly concerning tax obligations under the Foreign Investment in Real Property Tax Act, FIRPTE, and fixed, determinable, annual, or periodical, FDAP, income rules. The case overview: Gilbert v. NMACA Management Limited. Parties involved: Eric and Audra Gilbert, buyers, entered into a contract with NMACA Management Limited, a foreign entity represented by trustee Philip K. Leopard, to purchase a residential property in Peoria, Arizona. Jew. Contract details: the agreement, initiated in July 2014, was a contract for deed with a total purchase price of $1.2 million. Payment terms included a $60,000 down payment, a $90,000 lump sum by March 2015, 24 monthly payments of $4,750, and a final balloon payment in August 2019. Title issues: shortly after signing, the Gilberts discovered a pre-existing federal tax lien of $416,372.05 against the property, recorded months earlier. A second lien of $283,007.48 was recorded in November 2015. The contract was amended to require NMACA to resolve these title issues promptly and ensure clear title at final conveyance. Tax withholding dispute. In August 2017, the Gilberts informed NMACA of their obligation to withhold portions of the purchase price under FIRPTA and FDAP rules, as NMACA was a foreign entity. NMACA disputed this, claiming exemption from such withholdings. Legal action. The Gilberts filed a lawsuit seeking a declaratory judgment that their withholding actions did not breach the contract. NMACA responded by initiating forfeiture proceedings, asserting the Gilberts' failure to make full payments constituted a breach. Gierso legal proceedings and outcomes. District Court. The court dismissed the Gilberts' declaratory judgment claim, citing the Declaratory Judgment Act's prohibition on federal courts issuing declarations related to tax obligations. Ninth Circuit Appeal. The appellate court affirmed the dismissal, agreeing that the Declaratory Judgment Act barred their claim concerning federal tax obligations. Other claims. The Gilberts' additional claims, including breach of contract and wrongful recording, were addressed in a separate memorandum disposition. Your key takeaways. Importance of due diligence. Buyers must conduct thorough due diligence, especially when dealing with foreign sellers, to uncover any existing liens or tax obligations. Understanding tax obligations. Transactions involving foreign entities may trigger FIRPTE and FDAP withholding requirements. Buyers should be aware of their responsibilities to withhold appropriate taxes to avoid legal complications. Legal limitations. The Declaratory Judgment Act limits the ability of federal courts to issue rulings on tax-related matters, which can affect legal strategies in disputes involving tax obligations.